Okay, so hello everyone. Sorry for this inconvenience. I couldn't reach you at the in time, so we need to delay it and for 15 minutes. So basically, today we'll discuss about the IPR, and here there are item teams from Sydney, Peshawar, Brazil, and then Toronto, which is like very excited because we have very different time zone. Like from Australia, is it like 9 o'clock right
Yeah.
here, right? 9 o'clock. Wow, like huge dedication for that. Okay, um, so I will tell you the rules. So basically, we need to we will start discussing, and I'll put the question there in the chat, and then you can see it there. And from the first question, I will ask from the Sydney, and then Peshawar, and then from Brazil, and then from Toronto. So you just need to answer like for 5 minutes max, and then after all of the teams are like answering this first question, and then we'll discuss it like together, and then we can discuss it like maybe five for each team, but like because we have four of them here, so we can just make a broader time, like half an hour maximum. So we won't reach more than that because we'll like go and proceed to the second question, which is goes like for 5 minutes for each teams, and then we will proceed to the other discussion again, and then if it's necessary, we'll proceed to the other question. So the surprise question or the third, I'll tell you later. So it's just for the surprise, and now we'll start. But before we start, we want to hear about your projects, and just tell you, like us, we are crafting Croxin right now, and we are still actually last day, it was the last day for us to work in the lab. So basically summer is over right now, and then now we will try to compile everything and just get a result and something like that. And now we're still doing the ethics documents and everything, so we try to compile. That's why we also make this kind of discussion to like improve and then learn from all of you guys, something like that. So can you tell us from Sydney, maybe we will go through like the similar structure, so you will always get the first. So could you tell us what are you doing there?
Okay, so I'm actually joining this call to find out a little more about patent law because our project is actually about we're synthesizing insulin using bacteria. So in like the world right now, especially for countries like even America, it's actually really difficult for a lot of people to access insulin just because of we have a very big oligopoly essentially in the market. So price of insulin is really expensive and it's dominated by 3 pharmaceuticals. So we're looking for a way to actually synthesize insulin which is cheaper, better, and also more efficient and hopefully not infringing anyone's patents. So our interest is sort of finding out what we're doing is actually legal in the first place, because slightly debatable in terms of whether our the differences in our project will actually count as an inventive step or not, because what the criteria is in Australia for what makes something under patent and what doesn't. So yeah, that's mainly our project. So we're just trying to make something new and hopefully not get a lawsuit essentially.
Wow, that sounds amazing. Insulin, yeah. Everyone needs it. Like not everyone, but like yeah, especially related to the diabetic. Yes, human. Okay. So thank you really. There. We move to Peshawar. Hey, Mohammed. And who's there? beside you, so you can tell us about your project.
Okay. So we are working on detection of heavy metals in contaminated water. So it's more of like development of a biosensor for detection of heavy metals. So what I mean, that differentiates our project from the other projects is that we are going to engineer our device. So first we will test our devices into an E. coli, and then we will move towards fish. So but there are 6 heavy metals that we are going to detect, and almost we have completed our lab safety training, and our DNA will be here soon. So we will start working on our project in like 2 or 3 days.
Okay. So you were working with a bio reporter, yeah? Try
Yep.
to have a biosensor, yeah, for heavy metals. Okay, that's really cool. So yeah, now we proceed to Sao Paulo. Hey there. Can you tell us about your projects and your teams?
Can you hear me? Yes. Okay. So we are working with some bacterium that lives in the midgut of mosquitoes, and we are engineering it to produce anti-plasmodium peptides, which is the cause of malaria. So we want to interrupt the transmission of the pathogen with a vector, in the vector. We would like to we are trying to make a tool that can be applied to other vector transmitted diseases, but we are starting with malaria as a proof of concept.
Okay, wow, that's cool idea. Okay, so then we'll discuss it, yeah, with related to the question. But before that, Toronto, would you like to tell us about your project? Okay, I'll just mute you. Okay.
Yeah, good.
Great.
Yeah,
we can hear you.
We're working with CRISPR right now and working to make it more accurate and efficient by creating a light-activated system that will allow spatio-temporal control of CRISPR, and in hopes, because it has a lot of off-target shooting, that hopes to like regulate it or stop it from going at all, like cutting at all, so it doesn't cut incorrectly. And I'm on the policy and practices team, so for that we're exploring the different ethical concerns regarding gene editing, and we're interviewing, our main project is interviewing different professionals related to law, sociology, medicine, different end users, religion, to kind of gather different ideas about what major concerns are, and policy as well, and to incorporate all their ideas into a kind of video series.
Okay. Wow, great. Sounds you guys have a lot of fun, yeah?
Yeah.
So now we'll start the discussion with the first question. So you can see it in the chat there. And when I stop reading the question, we can start like 5 minutes for each of the team. And you can tell us your answer or your opinion or suggestion or many like related to this question. And if you have any like feedback or comments, just write it down on the chat first. Then I'll let you to answer or have the feedback like later after the first term of answer. So start with the first one. If a set data of has intellectual properties right associated with it, the holder of the rights may grant permission of reuse through a license. However, data that has no intellectual property right associated with it is sometimes restricted through terms of use, and courts in the US and elsewhere have found them to be enforceable as long as the basic requirements for voluntary agreements have been met. So the question, Like, do you feel that it is appropriate to enforce restriction on data that is otherwise free of any intellectual property rights? So, what do you think about it? First, from Australia, Sydney, Australia.
Is it possible to have a pass on this? Like, in the nicest way possible. So the thing is, I'm not too sure how this same system works in Australia. I've heard of like the terms of use applying in America and other countries like that. But in Australia specifically, I'm not too sure because the field of IP in Australia is just not very well understood, in my opinion, because we're just not very developed in technology or anything at all. As a result, this isn't something that we really have discussed much in terms of what can and can't be. And I don't think I'm a very opinionated person, which might not be the best for this discussion, but I can give feedback if I can.
Okay. Okay, thank you very much. So, yeah, but we can like share each other. I'll tell you also with how we will do in Sweden. So, yeah, that's fine.
Yeah.
Okay, so we can proceed now to Peshawar. Hey, Hassan. Yes.
Yep.
Now it's your turn.
Yep. I think there was a up and down in the internet connection. So I'll talk in a perspective of Pakistan as well as in synthetic biology. So basically here in Pakistan, we do not have that much strict laws on patents and intellectual property rights. If somebody has a patented a product or an industrial product, any invention or design or any trademark. So, but on the other hand, there are certain people who exploit the rules and then use it in their labs. So first of all, I would say that in Pakistan, working in, regulating the laws of the patent policy, there is a dire need of regulating it again so that nobody could exploit the patent laws. So as far as the terms of use with contrast to the patent is concerned, I would suggest that terms of use are, they allow more of research, more productive research. So because in patent research, trainership stuff and the research is limited to that company only. But in perspective of terms of use, if the terms of use are, they are like only limited to specific areas that the patents are not used by bioterrorists and other people who are exploiting them, then I would suggest that the term of use are more productive and more they should be employed in contrast to the patents. And in Pakistan, I shall explain.
What I feel is that there shouldn't be a total restriction on the product or whatever that thing is, but it is, I think it is appropriate to have some terms of use used in any way it could be exploited. So having the terms of use are, I think, they are necessary.
So in Pakistan, we have an organization named Intellectual Property Organization of Pakistan, which regulates all this, but it's not that much active. Research, going for patents, but it's like the other people who are on the negative side, they're exploiting the resources, they're exploiting it. So I think that in perspective of Pakistan as well as other developing countries, their situation is the same. Then the situation is same, and in these areas, laws should be implemented. But in perspective of those areas and those countries, patent laws are strict and people are educated about the terms of use, then I would prefer to use the term of use over there. So I think that's all for the first question.
Okay, so it's in between, yeah, between yes or no. But like if the regulation is correct or right, then why not? Okay, that's pretty cool. So thanks, Muhammad, and
iGEM.
the team there. Yeah, okay. Now we proceed to Sao Paulo, Brazil. What about your opinion about these to enforce the restriction on data?
So the question is, how do you feel? Do you feel that it's appropriate? So we don't feel that it is appropriate to have restrictions on data that are not protected by intellectual property, because we think that data are knowledge that should be shared with everyone, because otherwise you are stopping the development of other things. So we think if you want to protect something, you can patent it or something, but I think there is no need for these terms of use thing. And in Brazil, we are not 100% sure, but we think that there is not this mode of restricting data like in the US.
Okay, so yeah, so you have a bit different system there, yeah?
Yeah, we have a system that doesn't work very well here, so it's really bad. Like it takes a long time to have a patent approved, like 10 years or more. So it's really we were thinking about patenting, not this project from this year, but other projects, and it is really complicated here. So we think it's better to globally patent or going somewhere else to patent, because here we will wait forever and nothing will.
Maybe the advantage is that it's more cheap, but it's so slow. So I think that don't recompense, you know.
Okay. So you still figure out try to find the potential one to patent it, or like to have like your product get like what is it, better benefits if you want to patent it. Yeah. Okay, that's really cool. So now we proceed to Toronto. Please, Estee.
So yeah, I also don't know a ton about intellectual property, but I would say like I'm kind of more in the middle, because like you don't want to, I feel like you don't want to completely restrict people from access to data without intellectual property rights, but at the same time, like there should be some regulations in place where people can protect their data or their like information, to like, otherwise, like they said, like it becomes really difficult and less encouraging potentially for people to want to do research if they feel like, I don't know if I'm going on the right track, but if they feel like well, anyone can use it, or it's not protected initially because there isn't necessarily any intellectual property rights like initially, then maybe there'll be less motivation for them to actually pursue it, which is really important, because I mean, if people have their initial like data or ideas taken from them without any protection, then I mean, no one would, it would be harder to get credit potentially. But at the same time, yeah, you don't want to completely restrict data, especially if it has no, if it's free of intellectual property rights. So it's definitely not like, I don't think it's one or the other. It's pretty difficult to decide exactly, but there should be more of like a happy medium if possible. I'm not too sure where it falls in Canada actually, in terms of that specific question. I feel like
related to your project and your team project, is it like, do you prefer to like try to restrict it or like try to open it more?
For our team project? Well, I mean, I guess if we were to I mean, of course, like right now, we try and limit what we're talking about, right? So we don't want everyone to have access to it right away until if something came of it or whatever, then we'd be able to patent it, you know? So people keep their data or initial data secret for a reason, you know? So I think that, yeah, we would probably want some kind of like agreement where, you know, people involved in it wouldn't be able to like, you know, just share it willy-nilly. But, you know, so it's like, I feel like, you know, when you're working on your projects, you want to be able to have access to like, have the freedom to be able to protect it initially, at least.
Okay. Wow. Cool. We have like several insights about the this question. Yeah. Either we restrict it, but maybe it will get more benefits if we like open the data. Now we can proceed to the discussion. Do you have any comments like related to these questions or the other team's project or suggestion even? So because it's kind of global that people are doing their research and then try to not collaborate that much, because then like people can steal the idea, steal the maybe even the results. So that's also the issue if we want to open it. But then if we want to restrict it that much, then people will not know if like someone can collaborate. But is there any comments? And you can from Sydney. Wait. Yep. Wait.
Oh, sorry.
Yeah. Okay. So yeah, just to make sure that everyone who wants to speak, there is no red light on the microphone, because now I'm trying to mute and unmute you. So if you want to speak and then it's still red there, just click it. Okay.
Right.
Okay.
So I think the way I approach this will be really quite similar to how Toronto has actually approached this. So I sort of understand the question more after everyone actually has talked about it a little more, because I was like, what exactly do you mean by just a set of data? And I didn't realize that a set of data just meant like normal lab results or something along those lines. In that sense, I sort of agree that there has to be a happy medium, and that's the same thing for anything in the legal system, essentially. Like you can never really have something that is really strictly black or white, because it never caters for everyone, essentially. And that's the point of the law, that you want to have something which is a pretty even playing ground for everyone, so that people who want to have protection get protection, and people who don't want the opposite and want to collaborate have the same opportunity to. So off just like the basis of how intellectual property law is supposed to operate in the long run, and it's how it's supposed to like help people, and also it's how it's supposed to promote research, even though it's sort of, it's almost like a parody, like it's a paradox that you're promoting research by sort of restricting research, because people don't really want to do research unless you can have it protected, because you don't get money out of it otherwise. So I think one of the things I want to talk about will probably end up in one of the latter questions, especially in terms of like how, like whether an iGEM team should be patenting anything, even if it's open source. But yeah, I think what you patent and how you patent it is really dependent on like whether or not a set of data should or should not be like considered like private.
Yeah, couldn't agree more actually. So thank you. Do you have more comments or suggestion?
Probably not. Like I think the way this, like, I genuinely don't know how we can really improve the system other than make it a lot more transparent to people, because the main thing, at least in Australia, is that no one actually understands the system, because no one talks about the system unless you're actually like a legal professional. And intellectual property isn't really a legal profession, like, well, it is in Australia, but it's not a big one, because it's very specific to development and science. And unfortunately, Australia isn't really keen on that, because they decided to cut all our funding. Slow dig of the parliament. But so there's a lot of things that like I would like to like like understand more about like intellectual property, but even within our own university, when we ask for advice or something, they're quite reluctant, and the only thing they'll ever help you to do is to not infringe a patent because they'll be sued. So in terms of how to get around a patent, we aren't really ever told how to get around one for obvious reasons, but we do want the best in terms of, like, I think the way that the information should work and intellectual property should work depends on where the information is going, whether it's for like using the same like material to help a different country where like they just don't have the same access to these things. So there are certain agreements that I know of where like a patent won't apply to a certain country because of their status. But I don't know, it just doesn't seem that appropriate in certain cases. But where you're looking at technology which is really new and forefront, and it's not something that's being developed or something which isn't just like a human like thing, like insulin, which is just human, then I think it could apply, yeah.
Okay, wow, amazing. Yeah, that's also the thing that we need to like know about it, because like different system, different people will have a different purpose and stuff like that. So we have to go back. So this is actually my friend, Bacteriophytes, is just trying to help me with the technical details. So don't worry. So now we proceed. The next one. Do you have any other comments? Maria? Muhammad?
On the same topic or in the next question?
Okay.
About the same topic?
Yeah, sure. Maria, yeah? Okay.
Well, we wanted to say that we think this discussion is really interesting because iGEM is all about sharing information and building things together, and like we give our BioBricks to the iGEM Foundation and everyone can use them. So it's all about open science and open everything. But at the same time, we would like, we students now often would like that the projects go further and turn reality. And that we often need some kind of protection. But in our case, we noticed that too late in the case of last year's project, because we just made it like everything is open, we published everything, and then we thought, wow, this would be really cool, and there are people that are interested in producing it. So what do we do now?
You are protected.
Yeah.
Please.
So, but it's really a conflict because you want to share and at the same time you want to protect. So yeah, but our group from Brazil is a student organized group that comes from a student club that is a Symbio Brazil club, and it's like a biohacking group. So we are very for open things. And it's a little difficult to think about protecting anything because it's against our ideas, so to say. But I think there are ways to protect to protect something so that we can make a business of it, but at the same time don't block the development of other projects, of other research, by having everything, like keeping secrets. No?
Okay. Yeah, I also got several things like that, because now people try to enforce the DIY movement, DIY bio especially, and then people try to have like more collaboration and they progress more because they open their like sources. But then the other thing, like they couldn't also like protect it because now it's open. But yeah, something like that. But that's cool that it's also happening in Brazil. So you can like compare between which one is better, and then if it depends, then you decide, something like that, right? Back to you. Okay, so actually we also got Göteborg, yeah, here. Okay, so but yeah, we'll proceed to the discussion first with the Toronto. Then I'll let you know to answer the question. You can find it. You could get you got it from the email, right? Or you can see it in a chat there. There's a question also. Or I can post it again.
Yes.
Okay, cool. So now we proceed to Toronto first, and I'll let you know. Yes, I'll let you know after Toronto iGEM teams. Okay, now Estee.
Hi.
Hey.
Yeah, so we're just going like kind of the last question area on patenting our projects. Is that what we're talking about?
Mm-hmm.
Yes, definitely. It is my first year in iGEM, so I don't know everything that they've done in the past totally. But I know that like when we start, right, you sign papers and stuff to make sure that like initially it's kept secret or not totally secret, you know, so you aren't sharing everything, or if something did come of it. And they've definitely talked about in the past, like it has potential, who knows, you know, if your invention works, then you can definitely take it to the patent level, because like, why would you pass up that? So I think they do always, we do always like consider the possibility of patenting things. So I think initially that's why they have you sign forms and stuff, if that did ever happen, because they want to make sure that everyone's like on the same page and can, and the project can be protected mostly. So I think, yeah, I think we kind of go at it from like it could happen. So, you know, always be prepared. And I protect it in every way possible. Obviously, we share it publicly at Jamboree, so you can't protect it totally. But yeah, so I mean, we definitely have thought about it. And I do think like it is appropriate, because it's still, just because you're doing it for a competition doesn't mean that it's like not your ideas and your data. So I mean, like people, it doesn't, I mean, I don't think it belongs to iGEM just because you participate in it, unless I'm wrong about that. So maybe if we were like a company or a group of scientists working with a particular company, then we might be restricted in what we do because it could be their property. But I mean, if it's not iGEM's property, then it's still our data. So I think it's totally reasonable that if you come up with it and it's yours, then you have the opportunity to patent it or to protect it.
Mm-hmm. Yeah. But that's really cool. Also, like we have to know what to offer, and then what's the rules there. So it's not just a competition, but we also doing that stuff. So we own it, something like that. But yeah,
like
we have to thing in between. Yeah,
it's yours, right? And I'm sure if you did work so hard on something and it was like worth millions of dollars, then like you don't want to lose access to that.
Yeah, sure. Okay. So thanks, Ase. And now we move to Göteborg. So sorry for the technical details. Maybe you also didn't get the link or something like that. That's why
No.
you came late. Okay, but you received the question yesterday, yeah?
Yes, just the evening.
Yeah.
So we read them.
Okay. So what's your opinion about the first question? Do you feel that it is appropriate to enforce restriction on the data or restricted data? Then otherwise, it's free for any intellectual properties. Do you feel it is appropriate, or like, in between, or?
Well, I would say in between, because it depends on what kind of data it is. Like in terms of use, there's the privacy policies that you can't share data that is from a person, so you can't like distribute the personal information of someone from someone, because that's not, at least I don't think that's ethical correct. So to take that in consideration, the terms of use is there in a in like a positive way, but of course there's also there's negative things about it as well.
It shouldn't be like limited, so that if there is data, but you don't necessarily have to link it to people. You can still do a lot of interesting research on it, and you shouldn't limit all data. So we definitely think that some data that we should be able to use some.
Some other thing that we also talked about before this meeting was that how you actually can take patents on data. Of course, you can take patents on the equipment that you use for generating the data. And since the data always has some kind of error, you can never copy a data of doing like if you want to generate the same type of data using another equipment, you cannot. You can never generate the exact data as someone else. Although you can come to the same conclusions, maybe, while generating data from with another equipment. So I don't know, but yeah, but you can never copy data in that way. If you get what I mean.
Yeah, sure. So yeah, still we have to be like aware with everything about our data, which is like go through or like no, this is just for ours because like no, we don't want other people like make the same mistake. But that's also good. So yeah, but related to your project, we haven't heard it because you just joined us, right? Related to your project, like you already like spread some data of yours, or like you just want to keep working first and then get the final result, then afterwards you'll like publish it or like patent it, something like that. You're working with the biosensor, right?
Yes.
Yeah.
I mean, the way that we are working in it and the stage that we are in, we are still very, I think, open to like public data or like show all of our data, for example, at iGEM, because our biosensors still need work before patenting it. So the way that we, at the moment, like how we are gathering the data from it would probably not be the exact way that you would patent it if you would do that in the end to create a screening method and actually patent it and use it. So in that sense, it still needs development. But if you were to want to actually patent it, it wouldn't be the best, I guess, to show your data because then you can't patent it. So.
Yeah, sure. Okay, thank you very much. So, is there any other question, suggestion, comments for the first attempt? No?
No, I don't think so.
Okay, for all of you, if you want to comment it, just let me know, and then I'll like give you some time, like last, but then like we can proceed to the next question if you don't have any. Okay, we can go for the next. Okay, cool. So now we are moving to the second question, which is like, unlike the other intellectual property rights, patent has to be applied for and in most countries granted by a public authority. And are you aware of the rules that governs patent application in your country? Is this something your team has considered? you that seeking patents is appropriate within the context of the iGEM competition? Like Sydney got informed us already, and I can tell you, like in Sweden, maybe from Chalmers can also like add more. Like in Sweden, everything who is doing like in the university or like the students or the researcher there, if you can find anything, then IP or something like that will go to the person who found it or something like that. So university cannot just claim it. Even like here in Uppsala, there is an innovation center there that can provide helps to go through these kind of mechanisms. So maybe you can tell about your team and what, or like in your country related to this question. Start from Sydney. We'll go the same structure, yeah? Wait, I need to unmute you. Yep, sure.
All right. So in Australia, I'm not sure how similar it is to other. Sorry, just 1 second. That's my supervisor. Bye. Sorry, my supervisor just put his face against the window. So in Australia, I think how our patent system works is, at least if you do it in uni, it's actually governed by the university, but it's not like, I don't think it's the university owns your work, but they definitely have to do most of the paperwork in terms of actually making something into something that is patentable. So everything that you do, it will still go through the uni. They have their own sort of body to get work around it. Is why that, like, there's like a sort of group that is sort of in uni, and it's called UAEM. I don't know if any of you guys have heard of it. It's called Universities Allied for Essential Medicines. And what they're trying to do is they're trying to introduce into unis a sort of more like a, what's it called, a system of like IP, like one which is coherent between all universities, so that you can actually transfer like your work across different universities and between different people without having to go through like everyone's different IP laws. If that makes sense? Because every country has something which is slightly different. So the idea is to create something which is more universal, like a sort of more like a universal jurisdiction on how intellectual property should work. I don't know how feasible that is right now. Like, we've tried to talk to like the people who do work with most of the patents in like the Sydney University, but you get like, it's really difficult to, because they're not that willing to work with you, and it doesn't work unless both parties are actually interested in something. So right now we're actually, so the only person who doesn't really know about a project is one of the newer teams. Hi. But so pretty much there's a patent for a certain insulin. So they've made their own sort of insulin strand, and what we're trying to do is we're using one of the ideas, but sort of changing around amino acids and also changing its production to try and get something which is a better product, essentially. So we're trying to figure out if what we're doing is actually infringing a patent, like a patent law, because in Australia, all you need is something they call an inventive step, but that's a very broad brush term in terms of what actually is an inventive step. So no one really knows, and no one's like really that sure on what is and isn't under patent, because the way that they just work is just not transparent enough for us to figure it out. So within like our team itself, it's actually a very big issue, because you're not allowed to submit a patented part into the iGEM registry, which takes away some of our parts. So that's just one of the things that we do have to think about. And about, do you think seeking patents is appropriate within the context of the iGEM competition? I think for us, at least, to make what our project, like to actually get the benefit of our project, the work that we do actually in the end has to be patentable. Otherwise, pharmaceutical companies will never use it, if that makes sense. So the only benefit of our work really comes when like a commercial company takes it on board to take on our work to actually distribute it. So in order to do that, our work actually does have to have a patent on it, which is a bit ironic. So we want it to be as open as possible, but in the end, it does have to be patented for it to be distributed to everyone. So yeah, it's a live issue, I guess, for us. So it's going to be really interesting to see how every other sort of country deals with it, because I don't think it's the same everywhere.
Yeah, like every single country, they have their own rules maybe, and also paperwork, which is like a bit annoying, but like still, if you want to get like more money or like collaborate with the, like as you say, company, then it has to be like that.
Yeah.
So yeah, thank you. Now we proceed to Peshawar, yeah?
So
Yes.
in perspective of our project, we haven't decided to go for bioentrepreneurship yet. And as far as the patent is concerned, we are not going for patent because I think that we have discussed it that synthetic biology is more of get, give, and then share. So it's like the open science allows more productive research. So as far as patent laws in Pakistan are concerned, in Pakistan Patents Office is that is a part of intellectual property organization. It deals with the patent-related procedures. So in order to be considered for a patent, there are certain criteria which are needed to be met, and the product should be new, like dimensions should be like productive, and then it has certain inventive steps, and it is capable of industrial application, that is more of its industrial production and its commercialization, and it shouldn't be contrary to law or morality, and there are certain other issues too that are related to its ethics and social issues, and there are also the bioeconomy concept involved. So then there is when someone files a patent in Pakistan, it takes like years to get approval, and we have to pay fees after 5 years each year, and then there is a 20 years contract. So, but after that 20 years, then it is an open source. Anyone can use it. Anyone can use it in their lab or whatever the product is related to. So, but I think that we are not going for patent, but our project is mainly related to biosensors. Then in Pakistan, heavy metal contamination is a really serious issue. So we are thinking that we should keep it in open source so that anyone can use it and develop a biosensor so that they might use it in their fit form. So I'd like to quote a saying of Dr. Salk, who developed the polio vaccine in 1950. When someone said that, Doctor, would you like to develop a patent on the polio vaccine? Then he replied that, could you patent the sun? So no, I think that it benefits everyone. So I think that the products which benefit humanity, so they shouldn't be patented. Patenting involves more of like industrial applications. I mean, money from it. That concept is mainly used in patenting, but I think that it should be open source, but there should be some laws, or you can say that regulations, which should keep the citizen scientists or the those persons who are involved in do-it-yourself biology, so that they do not use it for negative purposes. So I also think that how IPR applies to synthetic biology is that we should decide that how it is available to the public and how it is protected. So that's all I think.
Yep. Thank you very much,
So
Mohammed.
you're not audible.
Yeah. Sorry. Yeah. Nice. Yeah. I was saying the same. So it has to be like what is it? Long planned or long-term plan for like patenting stuff, like related to the iGEM results and like that. So yeah, sometimes just like I just want to like open or like make it open for everyone. So something like that. But yeah, that's cool. Cool insight. So proceed to the Sao Paulo iGEM team or Brazil iGEM team. Yeah. So yeah, Maria.
Well, this year we are 3 Brazil iGEM teams, so we are not the only one.
Okay.
First of all, we agree with Sydney that all PI world is not transparent for everyone. So you usually, when you read a patent, you cannot fully understand what is covered, what is not covered. Only lawyers that have studied that can manage patents and these things. So it is a little closed. No? The second thing is that here in Brazil, the rule is that you can patent anything that, well, not anything, it has to be patentable and be new and these things, but the special thing is that you can patent something that has been published in some way, but only within 1 year. After this year, you cannot patent anything that has been public in, like in a conference or in a journal or like that. So we could not patent something in Brazil that we had like, I don't know, 2 iGEMs before, because it's open now. We don't know how that works in the US or in other countries. We would like to know that, if you know, if we can patent things that have been published for some time. And
you need to some concept proofs.
Yes, you need to present a proof of concept. Or you cannot patent an idea only.
Say just, is this one? So I will be patent. Now you have to do some tests and a group analysis and spend a lot of time. That, how we say, is like 10 years for say yes, it could be a patent.
Okay. The next thing was that I looked up in the iGEM site, in the website, and you only okay. the parts in the iGEM registry are open for everyone to use, but if they are patent outside the competition, you cannot use them for commercial purposes. So you can protect your parts even if they are in the iGEM registry. Okay, the last one.
And how say the Pakistan group, in our case, is that project don't have a, it isn't like a patent because it's more application, social application. So in this case, we don't think about the patent. It's more a work with the government of the Brazilian, and
for other countries that are affected by these diseases, because no one will pay for curing malaria or these diseases, because it won't give money back. So in the case of our project, like the Peshawar project, we are not interested in patenting.
Okay. Okay, thank you, Maria. But your opinion also gave us some insights. So thank you. So now we proceed to Toronto. Wait, I need to unmute you. Let's stay. Yep.
Sorry, my roommate just slammed her door.
No problem.
Yeah, so kind of like we're still just talking about our teams, right? Kind of like what I said before, I guess. Like I don't know that we're considering anything right now, but we would potentially, like, if something came of it. So that's why we usually, I think, have some sort of something established so we can like address it if it were to come. So I think you should definitely, like, all the iGEM teams should be prepared because they are all potentially patentable projects. So just like we would come like prepared and have people in the project sign forms and keep some of it private in case we were able to patent it, we wouldn't want to lose the rights to do that. I don't know necessarily if that would happen this year, but I'm sure that it's possible with any project.
Yeah. But are you aware, or your team also aware about the how to patent in your country, or like
how to patent in our country. I'm not too personally familiar with it, but I imagine it's pretty similar, I think, to like the United States, where like you can, if it's a new project that hasn't, or some innovation that isn't already patented, then you can patent it. I think you can get a patent for, assuming they approve it, for like 20 years, and it's through the government, right? But you do have to apply for them. But I think it's pretty similar, and I think it's you keep it for 20 years, and then you have to keep reapplying every 20 years.
Okay, that's similar then, yeah. So thank you, and now we proceed to Chalmers. Wait, I unmute you, Tuva.
Yes. Yes.
Yep.
So I mean, you mentioned some of the Swedish laws and how it works with our universities. So we have looked into like patent laws in Sweden, like in general, and what you can patent and not, and discovered that for our biosensor, for example, we could technically patent it, like if we would, but if we would want to, and like if we produce it as the full like idea, and like, but not as, I don't know how to say it, like, if we would produce and perfect it, like, so not as it is now, but like technically we could patent a biosensor in a way.
Okay.
Yeah, because our project is, first of all, that we have a yeast strain that will sense to two different molecules that they are found in the breath of lung cancer patients. So if we wanted to patent it, we could by Swedish law patent both the yeast and also the prototype, that like the machine that you will breathe in, the patients will breathe in, so that the breath will come to the yeast, and then it can sense if the molecules are present or not. And also we have thought about if a project works, we want to create a screening program, so that those that has the highest risk of getting lung cancer, and like annually can go to the hospitals and check if they have lung cancer or not. And to do so, we believe that the easiest way to do it is to like create a company that produces both like the prototype and the yeast strains, and then cooperate with like hospitals and cooperate with the hospitals, and to like survive economically. We believe that a patent would be beneficial. Although we know that our biosensor needs some development. For example, the different lung cancer patients express different molecules. Ours can only detect 2. So that would be of interest to see, to develop the biosensor so we can detect more molecules. But we still think that the patent will not stop the development, because
it of course, like when you patent something, it might be harder for other people to do research on it, but creating a company and like patent it in a way would also make it more public, and can also increase people that are actually interested in it and want to like do like make it better, and maybe do another patent on it, and like, because people are like competing against patents, and in that way science also goes forward, even though you patent things. But of course we know, like when it comes to our project, we are when we go to the iGEM competition, we are going to like present everything we have, like, and in that way we won't be able to pattern it technically, but like how our biosensor would work if we would put it into a reality, a patent would be interesting. Even though we as a team won't do anything with it.
Okay. Yeah, that's also need to be like considered. Yeah. Okay, thank you very much. So now we proceed to the discussion part. Like now I open it, like any of you wants to give a comments like for other teams, or even like you wants to like suggest something. So anyone is interested?
Yep. So
okay, Muhammad. Sure.
Basically, our project is funded by the government. So I'm not sure if they will commercialize it or go for patenting or something like that. So does any one of you or your team is being funded by the government or any funding agency, and they have right to commercialize it or going for patent like that? I just want to ask if any of you is being funded by the government and they have right to commercialize it.
Okay. So, well, so you were like, tell us like your project is actually funded by the government.
Yeah.
And okay, and you ask if we have similar stuff, something like that. Okay, so now like any iGEM teams here like get funded from the government, or like you just have it like from the university or your supervisor, something like that? So anyone can answer it from Mohammed?
Yep. Basically, I just want to ask that if the government funded, so the team or their PI give the right of commercialization to the government?
Yeah.
Okay.
From
what? No.
Is it wait? Wait. You is it like okay? So from Australia first, maybe.
Yeah. So we're not funded by the government or anything, but we are funded by like the university. So from what I know, I think a lot of the work that we do is actually like the university covers pretty much everything. But like, I don't think. Yeah, I think it really depends on like how your funding works from your government, because that will actually mainly determine it, because it depends on like the sort of relationship that you guys have. Because for some people, I know that their patents are just their own. Other people have like an agreement when they first do iGEM that it is like done by like the university themselves. Like it's considered as a university project rather than an individual one. So they do own those rights. But other than that, like, yeah, it's not something that we have in Australia, because Australia's really independently done. So every university pretty much funds their own. And we know a team in like Auckland who are just self-funding as well. So like they don't even have like an actual professor who overlooks them or anything. So I think it really depends. So I don't, very helpful, I'm sorry, but yeah, you should probably like chase it up if you really want to find out like how it's going to work, because you're not going to be able to find it out on your own, honestly. Like, yeah, it's hard.
Okay, thank you. Yeah, also, yeah, I think before you were working with the project, maybe you could also have an agreement between both of you, like how to share something like that. So it could be clear to have it in the beginning of the project, I think.
I'm not sure about that. Actually, the agreement was signed by our PIs and the government cards. So we do not have access to that.
Okay, yeah, sure. But yeah, if you have the supervisor there, so maybe you can start asking like how's the limit and something like that. So you could also like, yeah, like from Sydney say like, yeah, you have to chase it. So yeah, is there any other comment, suggestion? I think Estee wants to speak, right?
I was just going to say that I don't think, as far as I'm aware, I don't think we have any government funding either. Most of it, yeah, we don't get it specifically like from like University of Toronto, but we get it from like different departments within the university. So you have to ask, like, because each department has their own funding. So like we have different colleges and we have different like arts and science programs and like engineering programs. So we ask like individual programs if they'll fund us, and usually they do. So give something, but it is kind of I think, yeah, we found it difficult sometimes to get funding or get enough. But yeah, we generally just have to ask like individual or like also outside groups outside the university. So like science related groups outside for my, rather than like the government.
Yeah. Thank you, sir.
And sorry, I'm just letting you know I'm gonna leave in like 3 minutes because I have to go.
Okay. Yeah, no problem. So yeah, is there any other comments or suggestion? Because you have sorry, you have some from iGEM Sydney, yeah?
Yes. So I just wanted more like a open board question, like how effective do you think a vaccine could be? Like this is sort of also to the Pakistan team, and when you were talking about polio vaccine and you said that you would rather keep it open source, but like what we were really interested in, because we are thinking it's not a vaccine, but insulin's sort of also a treatment, but how would you really approach it? Like, do you think it's actually effective, like practically, if you don't patent like the technology behind a vaccine or something to have it actually distributed to people, because it has to be sellable before it actually gets to anyone. So you can have like the entire method and the entire project open source, but no one's going to actually take it on board and actually produce whatever you have commercially unless it is patented, if that makes sense. I don't know, that's what we were talking about, because we weren't sure if like developing something which is suitable for like a third world country will even have a benefit unless it can be patented, if that makes sense.
Yep, thank you. So yeah, Muhammad have to answer it, right?
So I think that there are certain different type of projects that are it depends on the type of project. It should be patented or it shouldn't be patented. For example, if there is a project like production of vaccines, as he has given the example of production of vaccines. So if a company has a patent on it, why not sell it to the developing countries? So I think that that will raise many issues, because there in the world people die each year, thousands of people die because of different diseases. So if a company develop a patent on a specific product because they want to sell it, they want to be the only guys who sell it, so that will raise issues. So because those people who are dying because of unavailability of the treatment, they might not be able to afford it. So what I'm trying to say is that it should be open source, so that the methods should be open source, so that people in any country can do it without buying that high price stuff. So also, and there are certain regulations that should be implemented on the procedures that are not patented, so that they shouldn't be negatively.
Okay. Did you get the answer? Or kind of.
I think the issue is like, it's not the fact that it's not open source. It's more like even though it's out there, the ability to actually produce it, to make it actually cheap for people, and to make the vaccine actually usable by people, it requires something which is really large scale for it to work. And the only people who can do these things large scale are companies. So in the end, we still have to end up pitching everything to the companies to make them produce it, because we can develop like what we need to like cure something, but it won't actually ever like go on foot unless someone actually does it. And like you can have small companies, like I know there are small companies like which do produce like things like insulin privately, but like it's just not big enough to actually be viable for them either way. Like what you're producing and like what you've developed might be like the only solution, or it might be like a better alternative, but it doesn't work unless someone will actually use it, you know? So you can do it in the lab and you can help people in the lab, or like just like a small area, but it can never be something that is like really widespread until you actually have something that is under patent, unless there is an alternative. I'm just not too aware of it, if that makes sense.
Okay, I would like to just add one point. I think that there is a vaccine for hepatitis C, but it is too much costly, and I think the company has patent on it, on the procedure for production of that vaccines for hepatitis C. But here in Pakistan, that cost is too much. Only a millionaire can afford that cost. So what I'm trying to say that everyone should have access to it, but the rules should be regulated. It should be regulated. It should be regulated with certain rules.
Yeah.
Okay.
Okay.
Thank you. Yeah, both of you. Also, Esther, thank you very much. Oh, she left already. But yeah. So is there any other addition, like suggestion, comments? Maybe from Miria or from Tuva? Is there any? Okay.
Okay. So we agree with Mohammed that you don't have to patent things that won't give benefit, you know, because like for example, we are developing a solution against malaria. Which company will buy, like, license our patent to produce that if they won't get anything back? So it's something that we have to do together with the government, with the health part, and they will have to invest on it, like vaccines, or because for example, in Brazil, the government produces their own vaccines. Because who will pay for something like that? It's like if you patent something, it's because it's worth something. Someone will pay. For example, they want to clean up heavy metals in Pakistan. Does someone in Pakistan will pay for things being cleaned up? I think only like government or something, not you won't make a company that will get money for it. So it makes no sense for me to patent it, because you have to pay to patent and you won't get anything back. It's more like charity.
So I think that as everyone is talking about in perspective of Pakistan, here as I give the example of a vaccine of hepatitis C, that there are certain products which are not affordable. So I think that if we produce them here in Pakistan, then they will be cheaper. They will be much cheaper than their costs are being, and the cost which is represented by the companies which hold the patent for the product. So I think that my point is those products which benefit the humanity. So it's like which can save millions of lives, so they shouldn't be patented.
Yeah.
They should be available in open source, but they should be regulated.
Yeah, I also really sure that all of us here just try to be like to find a better stuff and for better like human living. So yeah, just don't get trapped with all of the offers, but like keep doing good, like something like that. But yeah, so we almost have all of the discussion, or like Tuva wants to add more, like something? No? Okay, so basically we have like already an hour and a half, maybe more. So sorry for the inconvenience in the beginning. So but we tried to do it because some technical problem, especially with the headset and then something like that. So we couldn't provide a better equipment. But yeah, so I can have a small conclusion that now we know like several countries, we have a different system, different offers or like kind of paperwork that we have to do with the IPR. But we also have to consider about the benefits of doing the patents or like similar things, including like how it will like limit the collaboration, something like that. So we need to consider all of this stuff, and then before going for the patents or even the open source. So yeah, that's all. So I haven't have the time had the time to provide you the third question, but like after all of this session, so this is the last, we Uppsala iGEM team will post all of the questions there, so you can answer with your iGEM team, and then you could have it as an ethics session or assessment, sorry, like assessment. Okay, so it's nice for having this discussion. Looking forward to see all of you in Boston, maybe this November. So thank you very much, and see you. Good luck with your project. Bye.
Bye.